Thank you, Janet. Welcome back from lunch, everyone. On behalf of the ICDR and ICDR Canada, it's my pleasure to introduce our session this afternoon on proposed changes to the ICDR Canada Canadian Dispute Resolution Procedures. My name is Liz Robertson, and I'm a director with the International Center for Dispute Resolution. The ICDR is the international division of the American Arbitration Association, and the ICDR Canada, as part of the ICDR, provides dispute resolution services for Canadian domestic disputes nationwide. As director, I handle case administration services for the ICDR's Canadian arbitration and mediation cases. In this capacity, I'm very lucky to work alongside my colleague, Steve Anderson, who is here with us this week in Toronto. Steve needs no introduction to many of you in this room, as Steve has done extensive work over many years as Vice President with the ICDR, developing the ICDR Canada and our relationships here with our friendly neighbors to the north. Steve has been instrumental in so many efforts throughout our organization, and I'm thrilled to say that most recently, as Division Vice President, Steve leads the AAA ICDR's mediation and upstream services divisions, where he will continue to lead our organization's efforts in these spaces while remaining pivotal in the leadership and development of our services here in Canada. So thank you so much to Steve for all of your continued leadership and guidance. Thank you to CanArbWeek and the organizing committee for hosting us. It's wonderful to be here in Toronto to share and exchange ideas about dispute resolution with you all. But today, our aim is not just to share our ideas with you, but to gather your feedback from the audience on some important topics and propose changes to our rules and procedures for Canadian disputes. Back in 2015, the ICDR Canada and the ICDR Canadian Advisory Committee created the 2015 Canadian Dispute Resolution Procedures, which is our current set of rules that is specifically tailored for Canadian practice. In creating the 2015 rules, the Advisory Committee analyzed the ICDR international arbitration rules and made changes to reflect a Canadian domestic arbitration and mediation rule structure that is tailor-made for Canadian dispute resolution practices, laws, and culture. As a result, we have the current set of rules, expedited procedures, and mediation rules that offer a complete framework for Canadian parties, counsel, arbitrators, and mediators across all provinces. The goal of these procedures is to provide party autonomy and the need for efficient process management by arbitrators and mediators, thank you, and the administering institution. So the current procedures were published and released in 2015. As we all know, the world we live in and the landscape of the legal community is not a static one. Once a set of rules and procedures is published, that's not the end of the story. As these procedures are utilized and time moves forward, there must be review, gathering of feedback, and thoughtful interaction with the users and potential users of these procedures to see what's working, what's not working, and to find out if and how the procedures can be updated to better serve the community. So the ICDR Canadian Advisory Committee is at it again and has been doing just that, helping us to look at the current rules through a lens of scrutiny and proposing some thoughtful and innovative changes to the ICDR Canada Canadian rules. We hope to conclude this revision process and publish amended ICDR Canada rules by the end of this year. So please stay tuned for that and more exciting news to come. So please stay in touch and continue to share your feedback with us on these rules and our services, both today and in the future. So huge thank you to all of the advisory committee members for volunteering your time and knowledge to help with this important revision effort. Brian Casey has been our fearless leader throughout the revision process, and today You'll hear from 4 more of the committee members who join us today as speakers and who I will introduce in just a moment. The format for today's session is that our speakers will present on various topics relating to a proposed change to the ICDR Canada rules. Our speakers will discuss and exchange ideas on some of the nuances, pros, and cons on the topic, and then we will ask the audience to vote. You'll see a QR code up on the screen and a URL. We'll ask you to take out your phones, scan the code, or enter the URL, and then vote in to tell us your opinion on the proposed rule change. We'll see the audience poll results in real time on the screen, and if time allows, we'll chat a bit more about the results before moving on to the next topic. We have 4 speakers and 4 general topics, so each speaker will lead us off on a particular one. But we want to make this conversational, so we encourage the other panel members as well as the audience to chime in as we move through the topics and share your ideas. We have until about 2:30, so I'll keep an eye on the clock and make sure we leave enough room for all the topics. So let me now briefly introduce our speakers in order of presentation. We'll hear first from Gerald Ghikas. Jerry is a nationally and internationally recognized commercial arbitrator based in Vancouver. He's served as sole arbitrator, co-arbitrator, or tribunal chair in numerous international and non-international commercial arbitrations, both ad hoc and institutional. Jerry has over 40 years of experience as arbitrator and as counsel in disputes concerning a wide range of industries. Next, we'll hear from Rahat Godil. Rahat is a partner at Baskin in Toronto, where she focuses on complex commercial litigation and domestic and international arbitration. Rahat regularly handles contractual and commercial disputes, international joint venture, shareholder and director disputes, and oppression claims. She has significant commercial arbitration experience and represents clients in both institutional and ad hoc arbitrations. Following Rahat, we have Olivia Dixon. Olivia is a partner at Osler in Calgary, where she is a corporate and commercial litigation lawyer with a primary focus on energy litigation, construction litigation, and international commercial arbitration. Olivia has appeared before the Alberta Court of Queen's Bench, the Supreme Court of Newfoundland, the Federal Court of Appeal, and in various alternative dispute resolution proceedings, including domestic and international arbitration and mediation.
There's something wrong with this microphone. I'm going to swap it.
Okay. Closing out our hour with the final topic, we'll hear from Christina Doria. Christina is a partner and co-chair of the North American International Arbitration Group at Baker & McKenzie in Toronto. In her practice, Christina assists corporations, public entities, and states with litigation and arbitration. Christina has appeared before the Supreme Court of Canada, the courts of Ontario, British Columbia, Alberta, and Manitoba. She's appeared before domestic and international arbitral tribunals, acted on arbitrations under most commercial and investor state rules, and has sat as an arbitrator under the ICDR rules and many others. So with that, let's dig into our first topic for discussion, applications for interim measures, and the question of, should the rules address an arbitrator's authority to grant such an order on an ex parte basis? Jerry?
Thank you, Liz. Let me begin by apologizing for being here again. I asked you all to pretend that I'm Brian Casey. You can attribute anything stupid I say. Pleasure to be here this time representing ICDR Canada. As you may or may not be aware, under the ICDR Canada rules, there are 2 instances in which arbitrators may be asked to grant some form of interim relief. There are two rules that address this. And the question that I'm going to be speaking to is whether in either one or both of those instances, the rules should expressly authorize ex parte applications. The first instance is under Article 6 of the ICDR Canada rules, which is the emergency arbitrator procedure, similar to what you have seen in, I'm sure, in other rules. The process in brief is that before a tribunal is constituted, if there's a need for an interim measure of protection, the party can write to the case manager at ICDR, and arbitrators can be appointed within 1 day. The arbitrator, emergency arbitrator so appointed, then has 2 days within which to establish a procedure for resolving the subject of the application. The rule as it currently reads says, the schedule shall provide a reasonable opportunity to all parties to be heard. The hearing, if there is one, can be in writing, by telephone, by video. There need not necessarily be a hearing. And this results in an order or award, which the parties, by having contracted into the ICDR Canada rules, they have agreed that any such order is binding on them contractually. And it will then be a matter for the arbitration law, wherever the seat is, to tell you what you might or might not be able to do with that order or award. And then when the tribunal is in fact constituted, the tribunal can revisit the subject matter, can modify, set aside, confirm the award of the emergency arbitrator. So the first part of the question is, should it be open to a party to make an ex parte application to such an emergency arbitrator before the tribunal is constituted? The second situation under the ICDR Canada rules is under Article 24. That's the authority, once the tribunal has been constituted, the authority of the tribunal to grant interim measures of various kinds. So that's the second scenario in which we ask the same question: should the tribunal be allowed to entertain ex parte applications for relief? The question is quite focused. It is the relief sought is narrow. It is, should there be an authority on ex parte basis to make an order, quotes, requiring a party to maintain the status quo pending the determination of an application for interim measures. So it's not to dispose finally of the actual interim measures sought, but to simply say, freeze the status quo on an ex parte basis until the matter can be heard on an inter partes basis. So I've been asked to debate with myself, which is what I do in the shower every morning. So it's I'm well practiced at this. I'm going to give you some pros and cons on this issue for you to think about, some of which you will already have thought of, no doubt, and then we'll take a stab at this vote that Liz described for us. So on the pro side, that is in favor of such a provision being added to the ICDR Canada rules. Many arbitral rules of other institutions do already allow ex parte applications for what are often referred to as preliminary orders, these status quo orders. For example, in Canada, the Banny Act, whom we heard earlier, their rules contain such a provision. In Ontario and in British Columbia, the modernized international commercial arbitration legislation adopts the 2006 model law amendments. They allow tribunals, which would include by definition an emergency arbitrator under any institutional rules, to make preliminary orders, these maintaining the status quo kinds of orders. And so these are, and in British Columbia as well, I should say, the Domestic Act for domestic British Columbia arbitrations also contains such a provision. On the con side, the unicitral approach has not been universally adopted, by which I mean this notion of preliminary orders being made ex parte. The working documents of the unicitral working group, which I didn't participate in this particular debate, but I have been a member of that working group, and I can imagine the fur flying over this issue. They're very strongly held views both ways as to whether it is or it's not appropriate to allow for ex parte applications in an arbitral process. When Australia was updating its legislation to incorporate the 2006 amendments to the unicitral model law, and this rule in particular, they excluded the power to grant ex parte orders. New Zealand went the other way. I think Singapore as well excluded the power. So far, as I said, the two Canadian provinces who have dealt with this issue have included the power. But it's not correct to assume that this is an issue without controversy. So next point on the pro side is what I mentioned earlier, is that it really is very narrow in scope. It's not addressing the merits of the request for interim relief. It is doing nothing more than directing one of the parties to maintain the status quo until the emergency arbitrator or the tribunal can come to grips with the merits on an inter partes basis. On the con side, that's what that point misses, is that in directing that the status quo be maintained, you may well be directing one of the parties on an ex parte basis not to do something. You may be directing them not to call a letter of credit by saying you must maintain the status quo, or not to terminate a contract, not to move an asset out of the jurisdiction. So maintaining the status quo sounds benign, but it may not be in the particular circumstances of the case. And these orders last until the tribunal is constituted. That can take a while. So again, when you're assessing the pros and cons for allowing an emergency arbitrator to do this, think about that factor. Last point, on the pro side, what's the big deal about giving this power to the arbitrators? Because a party could go to court on an ex parte basis. And why should it be within the power of a court to grant ex parte, hear and grant ex parte relief, and not within the powers of an arbitral tribunal, which is not a secondary level of justice. It's supposed to be of equal force and equal stature. And this is, when you think about it, if an application is made to an emergency arbitrator, that person will not be the ultimate decision maker. They will not be part of the tribunal when it's constituted. So that there should be less concern about allowing an emergency arbitrator to make ex parte orders, because they're just there for a short period of time, and whatever they hear isn't going to matter at the end of the piece. On the con side, the argument that's often made is, well, that's exactly right, you could go to court. And the courts are used to dealing with these things, and they have lots of jurisprudence and protections, so you don't need to be able to go to the arbitrator. No harm done. It's not like you're without a remedy. If you need ex parte relief, go to court. And that argument used to have more force because court orders were more readily enforced than orders granted by tribunals. That's not always the case anymore. At a philosophical level, I guess the ultimate point on the against argument is that arbitration is a consensual process. The arbitrator's jurisdiction is derived from a contract, from the agreement of the parties. The whole notion of allowing one of the parties to express their side of the case on a secretive basis without the other party having noticed that it's happened is just the antithesis of what the arbitral process should be about. So there you have the landscape of arguments that are mustered for and against provisions of this sort.
All right, everyone, phones out. I want everybody to get your phone out, scan the code, or enter the URL up at the top. And once you've done that, once I go to the next slide, it's going to release our question relating to Jerry's topic, where you can tell us how strongly you agree or disagree with including this type of instruction in the rules. So let's see what we got.
Liz, is the URL at the top still?
It is, yeah. So it's ahaslides.com/2yhs6. So we'll just give it a couple of minutes.
Also, while that's populating, does anyone in the audience have remarks? Do you feel strongly either way that this should or should not be the case, Anthony?
Well, it just seems like gilding the lily a bit. The whole purpose of an emergency arbitrator is to shorten the time. The purpose of the preliminary orders under the model law is to shorten the time. So I'm just trying to figure out why it's necessary to do that again. That's my views.
And I wonder, is there any harm that can follow without the guardrails? I mean, a Moreva in the common law system is an extreme remedy. It's kind of the nuclear weapon, that we have. And so with the guardrails that we have in the common law, I wonder, any thoughts on whether there's some danger in having it in the arbitration context?
Well, I don't know about danger, but when you say alternatives, go to court. If you go to court and say, fine, we'll give you an appointment 2 weeks away. If you go to court, and you say, okay, we'll give you an appointment 2 weeks from now to deal with this, that would be a completely useless proposition. And it's passed with arbitration. Why not give the power for an ex-party application quickly?
I guess you could get it quickly, but then how useful is an arbitration award that is a little harder to enforce, perhaps, right?
Well, the model law as adopted in Ontario and British Columbia distinguishes between these preliminary orders, which are not enforceable, ex parte orders, and other forms of inter-relief that have been the subject of an inter-parties application, which can be enforced in the same way as a court order. So there is an enforceability issue associated with these preliminary orders. They're still theoretically contractually binding. And so the parties are going to have to deal with potentially the same tribunal, depending on who they went to, with a tribunal that has would have expected them to comply with their contractual obligation to honor such an order. But it's that kind of moral force that is brought to bear on the enforcement court. I've tried not to let my prejudice affect my presentation. I'm not fond of this idea.
Neither am I.
See, it is a debate. All right, one more question up in the front. Eric.
Microphone, please.
The question I would have is this. I mean, if we're dealing with the situation of having to choose, like an interim order, maybe by an interim sort of arbitrator, to deal with maybe, say, some difficult situation that has come up and requires instant solution or resolution. But of course, the comment has been made that one could go to court and seek an order as well. And is it possible to say with any kind of certainty at all, just as at least as a generalization, I mean, if you do go to court, how long it actually takes to get an order?
I mean, in Ontario, under the commercial list, quite fast, and actually in BC, it's quite fast too. I tried to book one about a month ago, and I think in BC, like, once your materials are ready, they'll hear you within the week. It's pretty, if it's an emergency, it's quite fast.
So in other words, it may not be that there's any great time advantage.
Although there are a lot of former judges in the room who might entirely disagree with me, so.
Okay. Thank you.
Yeah, let's go one more in the front. Megan.
It's not just a question of timing, though. Sometimes these issues bring to bear a lot of sensitivities, and if the parties have to go to court on the public record about something that is urgently happening, you could see, as a direct result of that publicity, a huge decline in stock value, for example, a major change with the public reacting to something happening or not happening with the company. So there's good reason to not always just run to court for an interim measure. If you have an emergency arbitrator available to you, that would be a compelling reason to keep it out of the court system.
But one last question, if I may, is I don't have a sense of how real this issue is. I've been involved in a number of arbitrations. I've never asked for, never been asked for an ex parte order. And I'm wondering, among the people in the audience, how many of you have had experience with this in one way or another?
I had one case where I was asked for an ex parte, I said no,
Yeah.
served the other side, because it wasn't the nature that needed to be ex parte.
Yeah.
Yeah.
Is it opt-in? Is this an opt-in rule, an opt-out? You know?
It's not a rule at all at the moment. Yeah, I think it could be varied by agreement, but it would be in, I suspect.
Yeah.
So it's in, so it's opt-out.
Yeah.
All right, okay, in the interest of time, let's move on to topic number 2, expedited procedures and resolution of proceedings on submission of documents only. So the Canadian expedited procedures of the ICDR provide for both under our expedited procedures. It's a reduced time framework designed to reduce time and cost. How and when should these procedures apply? Should they apply by default to claims under a certain amount or only by agreement of the parties or otherwise? So Olivia, please take us through expedited procedures and documents only. Rahat, sorry.
Thank you, Liz. So I'm going to be speaking to a potential change that's being considered for Article 1.4 of the ICDR Canada arbitration rules. And just to start with some background on this, as everyone in the room is well aware, in recent years, almost all of the arbitration institutions have developed some kind of expedited procedure rules. Typically, as Liz mentioned, these rules provide for abbreviated proceedings. Sometimes they limit or eliminate hearings altogether. They establish shorter timelines for issuing the final award. And sometimes they vest the arbitrator or the institution with broad authority to truncate the process. Some of these rules also give institutions broad powers to impose a single arbitrator, even when the parties have agreed to 3 arbitrators in their agreements. These rules often apply automatically when the amount in dispute is below a specified threshold, but they also allow users to opt in for the application of these procedures should they wish for larger or more complex disputes. So the ICDR Canada rules are consistent with sort of the major international arbitration rules. When you look at, for example, the ICDR, the ICC, LCIA, the SEC, all of these and other institutions do have expedited arbitration procedures as part of their rules. Currently, Article 1.4 of the Canada arbitration rules provides that unless the parties agree or the administrator determines otherwise, these procedures shall apply in any case in which no disclosed claim or counterclaim exceeds $250,000 US. That's exclusive of interest and costs. Parties can agree for these rules to apply in other cases as well. They are set out in Articles E1 to E10 of the rules. And then the rule goes on to say that where no party's claim or counterclaim exceeds $100,000 US, exclusive of interest, fees, and other arbitration costs, the dispute shall be resolved by written submissions only, unless, of course, the arbitrator decides that an oral hearing is necessary. So the change that is being proposed to this article is simply to the applicable monetary thresholds. What's being discussed is whether the threshold of $250,000 US should be increased to $500,000 Canadian, and that would trigger automatic application of the expedited rules. And there's also discussion about increasing the threshold of $100,000 US to $150,000 Canadian, and that would trigger the determination of the dispute by written submissions only. So I'm going to first present a couple arguments in favor of this change, and then a couple of arguments against this change, and we'll be curious to see what my co-panelists and audience thinks. To start with the arguments in favor of this change, I note that this proposed change is not really a significant change. The ICDR Canada arbitration rules, as discussed, already include procedures for expedited procedures. So this is not a brand new provision, not a brand new process, not a significant change that is being implemented. The only change is to the applicable monetary limit. And that limit is not really being increased that significantly when you look at the changes. The current limit is already $250,000 US. So in Canadian dollars, we're already at approximately $350,000. And we're talking about just increasing that to 500. And for written submissions, we're going basically from 100,000 US, which is approximately 135 Canadian, to 150. So I would say the change is not huge, but the advantage can be huge. The advantage is that this change will allow more cases to be decided in a streamlined and more cost-effective manner. More cases will be decided quickly, more cases will be decided more efficiently, and you will see cost efficiencies. And those features are often, the biggest selling features of arbitration. Some of the big reasons why parties choose arbitration over litigation in the first place. And so I would say that this prospect of additional procedural efficiencies is useful. And what it will mean is that more parties in more of their dispute will actually be able to see the benefits of arbitration in practice. From an international comparative perspective, these thresholds for application of expedited procedures will continue to be well below the limits that we see in other international rules. And last but not the least, I would say that parties can always opt out of these expedited procedures. So if a party did not want these rules to apply automatically to their bigger value disputes or some of their disputes, they can always opt out of these rules, and so you're not really sacrificing party autonomy by accepting this change. So those are some reasons why this change is a good change and should be implemented, but there are also arguments against it. And I think some of the arguments against it are, it's sort of the converse of what I just said. Because these rules apply automatically, because parties don't actually opt into the application of the expedited procedure rules, they are a default, and they apply whenever disputes are below specified thresholds. It would make sense that these limits are kept lower as opposed to increasing them, and that would better serve arguably party autonomy. Of course, having a lower limit doesn't mean that the parties can't use these rules for higher value or more complex claims. That's expressly permitted under the current wording of the rules. Parties can agree for these rules to apply in other circumstances. And so they could do that either At the outset, when they're first entering into their arbitration agreement, they could agree at that stage for these rules to apply. Or at the stage, once you're in the post-dispute phase and you know what the dispute is and what the claims are and sort of what the complexities are, you can at that stage also agree for these expedited procedures to apply. So you could say this change is not really necessary. This change will make the threshold in the ICDR Canada rules higher than the current threshold in the ICDR rules and the AAA rules. And potentially could be perceived as inconsistent with the trend that we see in some of the other domestic Canadian arbitration rules. So for example, the ADRIP rules and the ADR Chambers rules currently don't have a limit at all. And the Banyak limit for domestic disputes is currently $250,000 Canadian. So this would be higher than that. I think another argument against it, against increasing this limit would be that higher value claims are more likely to be complex, more complex claims. And so a simplified or expedited procedure may not necessarily be the best procedure for resolving those claims. One may obtain a faster and a cheaper decision by using these rules, but in turn, you probably do give up or at least compromise somewhat on the quality of your decision and the quality of the process that you get in getting to that decision. There is generally an inverse relationship between time and money spent on one hand and the quality of the process and decision making on the other. So I think one could argue that changing and increasing this threshold will likely could increase potential prejudice in more cases as parties have to give up and compromise on valuable processes. I think it can also be argued that increasing the monetary limit can potentially also increase the potential for abuse. And I say that because this change may lead larger, more sophisticated parties to deliberately include these rules in their agreements with perhaps smaller, less sophisticated parties in order to gain tactical advantages, to prevent thorough development of issues in the course of a dispute, and to rush an important decision or to gain leverage in settlement discussions. So there's that possibility as well. So those are some of the arguments against it, and I'd like my panelists as well as the audience for other comments.
Thank you, Rahat. Everyone phones out again, if you will, and let's vote again. We have the claim amount ranges up here for expedited. Tell us what you think. And feel free to raise a hand and chime in with additional comments as well.
I just have a clarification. Sorry. Is there a transition time? In other words, contracts for parties who've already included an ICDR clause, will those automatically be subject to this new rule?
Is there a transition time? I'm not just asking because a current contract that agreed to a certain amount, the 250, but then finds the dispute arising after that with the proposed new amendment, I think is not with it.
Well, I think it depends on the clause, right? Is it, does the clause just adopt the rules in force at the time?
Well, usually they do,
Well, then,
but
But this is talking about no hearing, which the model law is pretty harsh with. I mean, I agree for other kinds of rules, but this is a pretty serious one, I think. The right to have an oral hearing.
Or oral hearing, right? So a hearing, I think, can be by submissions too.
Yeah, I mean,
And the
I hear you,
arbitrator
but I mean, I think I'll resist. I think it's a little more serious than that. I would think a transitional time might be a good idea.
Mm-hmm. And the rules do say that, the rules that apply unless the contract states otherwise would be the rules in effect at the time of the filing, unless the parties agreed otherwise.
And I think what Anthony's probably going to say is, well, one party who doesn't want to cooperate won't agree.
right.
Right.
I know how I'm going to vote.
But you always take that risk though, right? So Anthony, whenever in the contract parties say it's going to be the rules that enforce at the time of the dispute, there's
I
always
completely agree, but this is it's not like you have an extra 30 days or 20. This isn't the type of rule where the center has said, oh, you actually now have 10 days instead of 15. This is about affecting your actual dispute proceeding beyond what I would call merely procedural changes, which is what that rule is really about. To say, look, we over the years have figured out it's a little more efficient to do it this way. I won't take that.
No, but it's important though, because now the advisory committee can look at, do we now attach that type of a rule to some kind of, no retroactivity or something like that.
Mm-hmm. Exactly. And so we kind of have a follow-up question as well on this one, which is same question, but regarding application of the documents only procedure in addition to the expedited procedures. So here we go. Okay, so same question, but with relation to a documents only procedure. Let's see. Oh, people are changing their minds. We've got real time viewing the results. Okay, so mostly 150,000 Canadian or less. Interesting. All right, so I think we should keep it moving so we don't lose out on any of the topics we have today. Next, we're going to hear from Olivia on the topic of mediation. As it stands, the Canadian rules simply state that following the time for submission of an answer, the administrator may invite the parties to mediate, and at any stage of the proceedings, the parties may agree to mediate. Should this language be stronger, the ICDR international arbitration rules, for instance, say, subject to the right of any party to opt out, the parties shall mediate their dispute concurrently with the arbitration. Or is there another more creative option we could use in the rules that would better serve the needs of parties? Olivia?
Thank you, Elizabeth. So my topic today will be about mandatory mediation, which obviously has been a topic of discussion through the litigation process as well in recent years as we consider whether this is a valuable rule to include how parties have a mandatory mediation step. And as Elizabeth noted, the ICDR US rules currently include a provision that effectively provides for mandatory mediation with the ability to opt out of that clause in an arbitration agreement. So the question we've been considering on the advisory committee is whether the ICDR Canada arbitration rules should be amended to include the same clause that appears in the US rules, and this would be a change to Article 5 of the current arbitration rules. And we've really been debating three options. So the first option is to leave the language as is, which just simply provides, as Elizabeth has run through, that an administrator may invite the parties to mediate, and the parties may agree to mediate at any point during their arbitration. Option 2 is to change the Canadian rules to line up with the US rules, which, subject to that opt-out right, provides that parties shall mediate their dispute in accordance with the ICDR's Canadian mediation rules concurrently with the arbitration. And the third new option that we've been considering is a bit of a hybrid and a bit of a change to the existing language. So effectively, in addition to having the administrator may invite the parties to mediate in accordance with the ICDR's Canadian mediation rules, the administrator can also invite the parties to pick, on a without prejudice basis, a mediator who will be available during the arbitration to mediate the dispute at the invitation of the parties. So in other words, the administrator can appoint a mediator who's on standby if the parties elect to use that mediator during the course of the arbitration. So those are really the three options. And I'll maybe cut to the chase here in terms of what our discussions on the advisory committee have been. I think our group is generally not in favor of changing the rules on this point and more in favor of keeping with the status quo. So in other words, we haven't been particularly keen to adopt stronger language that would provide for more mandatory mediations and following the language in the US rules. But maybe I'll start by playing devil's advocate here, and I'll present the pro side of including the stronger language first. So the general rationale for having mandatory mediation, which I know everyone has heard before, is that it's intended to promote goals of efficiency and economy in dispute resolution. And having a mandated mediation may enable parties to reach an early resolution of the matter, even if parties don't think settlement is going to be possible. Mediation will also allow the parties to narrow the issues at an early stage of the proceedings, and one could say that is even if mediation is not successful, it will allow parties to really focus in on the issues that are truly in dispute between parties. Of course, mediation also enables a more flexible set of resolutions than what may be subject to be directed at the conclusion of an arbitration. So for instance, if there's an ongoing commercial relationship between the parties and some other gives and takes that could be part of a satisfactory resolution, mediation is a good tool to facilitate that kind of process. For those of us who like some uniformity, there may be an argument to say there's some value in having uniformity between the Canada and the US rules for ICDR, so that it's generally clear what the expectations are going to be in terms of things like mandatory mediation. And I think the last point in favor is this isn't really truly a mandatory mediation clause, and that the parties can always elect to opt out of it. They can always elect to waive the mediation provision, though I would say that this is something, if adopted, parties would obviously need to turn their minds to when crafting their arbitration agreements, and something that we would need to be mindful when we're talking with our solicitor colleagues about things they might want to turn their minds to when crafting dispute resolution clauses that the litigators then get stuck with down the line. So I'll turn now to the con side, which I think is where our advisory committee sits, not to taint anybody's views at the outset.
I have to flag, if there's people smiling in the audience, it's because like parts and things are just like not how you are. The enthusiasm is just off the charts.
I know there's some chuckles. It fits with our warm fuzzy mediation.
Yeah. Why vote when you could send an emoji?
So I'm not sure if that will change when I move to the con side.
We'll see.
So of course mediation will add some expense and time and some additional steps in the dispute resolution process, particularly if it's not a successful mediation. It could also be duplicative in some circumstances. So for example, if you have an existing arbitration agreement or an arbitration clause and a commercial agreement that provides for multi-tier dispute resolution negotiations, multi-step negotiations, to add a mediation into that fold, you can add just another additional step without getting much closer to a resolution. I think there is a view held by some, not all, that mandated mediation can be less effective than a purely voluntary mediation. It becomes more of a check-the-box exercise rather than a good faith engagement in seeking to resolve issues. And I would say, while there is that opt-out, the mandatory language arguably detracts from the consensual nature of arbitration, which is to provide parties with an ability to design their own dispute resolution procedures, and whether that should include any type of informal dispute resolution or alternative dispute resolution, and what shape that takes. And I would also note that having the more permissive may language would line us up with some of the other rules in Canada. So for example, the ADRIC rules include that more permissive may order parties to mediate with the written agreement of the parties, so that's more consistent with what we see in some of the other rules. And I'll make a few comments about the new option, which is a bit of a hybrid approach. It's still permissive, so it includes that may instead of the shall language, but arguably puts a bit more structure around planning for a potential mediation and having someone actually appointed who's there if and when an opportunity presents itself to really get into a good faith mediation at some point throughout the arbitration. And I guess the question that I'll leave with the group as we get into the voting is query whether adding that ability to appoint someone to be on standby really adds much to the permissive language that's already in the rules, or whether it's going to encourage further or better use of a mediator through an arbitration, or are parties likely to appoint a mediator to be on standby only if they're already pretty keen and serious about engaging in mediation as part of the arbitration? So we can take it over to the voting with that.
All right, so of those three options, once this changes
Let's
over.
ask the question, how would this mediator be appointed? How would the person be chosen?
So the rule as drafted, or the potential rule as drafted, would contemplate the parties selecting a person, and then the administrator would appoint the person that the parties have selected.
All right, so we can vote here on which one of those options do you like the best, keeping it as is with the simple may mediate provision, stronger language of shall, or the third hybrid option. What do you think? And if anyone has any other questions or comments, feel free. All right, and so far in line with the advisory committee's thoughts, keep it as is, simple may. Thumbs up. we don't know to which one, but. All right, large majorities on option A. Okay, so I think we should turn now to our final topic. We've been pretty party focused so far, turning our minds to the disputing parties' needs and what works best for them, rightfully so. But this last topic instead addresses a couple areas where we want to know how the rules could perhaps better serve arbitrators and mediators, not just the parties. So these areas of concern are tribunal cancellation fees, which we touched on a little earlier, as well as the tribunal or administrator's discretion to withhold delivery of any award or ruling until all necessary deposits are paid. Should such topics be addressed in the administrative rules? Christina?
All right, so I've already gotten some actual surprised faces, not just emojis. Can we actually go to the next slide so we have the word? There we go. Okay, so the first one, cancellation fee. I'm gonna we don't have all that much time left, so I'm gonna try to do this quickly. So some of the pros of having a cancellation fee, I think, what's going on?
They're voting over it.
So, okay, here we go. So pros, parties will really think about settlement, right? And they'll think about it early, at least before 30 days before the hearing, because they're gonna have to pay a fee if they don't, if they settle after that date. I also think it might keep the parties committed to the hearing date, so counsel are gonna be much more focused on getting to that hearing date. Maybe it means less delay throughout the process. And it also sets market standards. So what you have now is, well, first of all, in order to have a cancellation fee, it has to be decided up front. You can't swing it later. Courts don't like that, especially in Australia. But basically, if you do have a cancellation fee, right now it's kind of all over the map. And so different arbitrators are doing different things. So if ICDR were to do this, it would be one of the first sets of rules where they're actually setting the market to allow cancellation fees. Cons. In the ICDR billing guidelines for ICDR Canada arbitrators, they actually say that most ICDR arbitrators do not charge a cancellation fee. Institutions don't really love it because, of course, they're party focused, right? They want the parties to have an affordable process. But arbitrators, on the other hand, especially when they're neutrals, they don't, they're not at a firm where they can kind of necessarily take on other work. They're committing to that hearing date, and not taking on anything else. So there's that. I came up with a bunch of questions that I think are just food for thought, which may factor into how you vote or keep your vote. Whether ICDR should have an interest in arbitrators getting compensated. Is that going to attract more neutrals? Is it going to attract better quality neutrals? You know, are you going to have arbitrators who are more kind of willing and available to act on ICDR cases because it has this cancellation fee built in? So one of the stats is that 50% of cases settle. If that's true, then being a neutral is a really unpredictable income. And then does that affect diversity? You know, if you don't have a reliable income as an arbitrator, are we going to have a continued diversity problem in who we actually have sitting as full-time neutrals? Do case managers need to call parties to remind them of the cancellation windows? So they tell them, like, don't forget, you know, if you don't cancel by X date, you're going to have to pay. And then, of course, well, do you still note it in your biography online? Probably. And, you know, are people uncomfortable with the potential windfall that it might give neutrals for, you know, getting paid while potentially sitting on the beach, especially if your seat was in Hawaii? So what do you think? Strongly agree. Okay, show of hands. How many of you are neutrals and like only neutrals? Huh? Not that many. Okay. Why? Anybody? It's just standard now? Yes. Okay. So next, I've got 4 minutes. Can we move to the next?
Last question is up, so go ahead and vote on the last question, Christina.
Okay, so this one is, should the ICDR Canada rules include that the tribunal or the ICDR may withhold delivery of any award, ruling, or decision until the arbitrators are paid? The agreement with the arbitrator is essentially a contract, so why not? You know, if one party isn't carrying out their side of the bargain, then why should they get the benefit of the award? Are there situations where non-payment makes the proceedings impossible? But then what happens if one side pays and the other doesn't? I guess, you know, they have to pay the participating party has to pay everything. Let's see the vote. Strongly agree. So I did see some surprised faces, and I'm actually going to ask Janet, why do you think that this is an issue?
I think the institution should take care of that. I mean, I really do think it's really important for the institution to keep on top of the deposits. And when they see the hearing approach, for them to have a tickler in their system to say, hey, the hearing is approaching, or the cancellation moment is approaching, we should have enough in the kitty to cover that in case the parties cancel. And I just don't think it should be on the arbitrators to pull the plug. It really is, it's not very seemly.
So in other words, what you're saying is just make sure that the deposits are always paid, so you have a flush account that can be drawn from. Now, if that account isn't being paid, can you stop the arbitration? Does the arbitration become impossible? Or do you have to continue?
I've seen, not ICDR, but I've seen that very thing happen, and it's disappointing. It's disappointing. The tribunal says, well, I think we need more, and they say, oh, no, it's all good. And then before you know it, the parties cancel, and you're left without the cancellation fees. I think once, if they settle, you know, it's over. You may say, hey, like, you know, I should have been more careful, but I should have been clearer with the deposit, but it's over once they settle. Or once you deliver an award. It's like the costs award, at least internationally, the costs award in some separate proceeding after it's over is kind of, you know, unclear. It's over.
I have seen some arbitrators kind of creatively build that into their cancellation policy in the sense that the amount of the cancellation fee is paid in the form of a deposit in advance and then only released in the event of a cancellation. But
in ad hoc, around here, it's very common in arbitrators and gone over the deposits to say, I finished the award, I'll release it once this further amount is paid by each side. That's quite common. And that happens when the deposit is, you don't expect to have more deposits, but everybody's got to agree to all more deposits if required.
I think, over to you, because we're at 2:30.
We are at time. No, thank you all so much for your participation, your votes. Please continue to share your thoughts.